Hello, my dear friends. Svetlana Shlapak, the founder of UKVisaSuccess.com is here. So you have your global talent visa application. My sincere congratulations. This is not an easy visa to get. Now you probably think that you're at the very end of your journey, whereas in fact, this is only the very beginning. And you need to understand a number of rules in order to qualify for your indefinite leave to remain application. In this video, I explain the three essential key elements for your successful settlement application. So let us begin. Can you settle in the UK after you received your global talent visa? The answer is yes, absolutely you can, provided, of course, you meet all three elements of your settlement application. Before we look at these three elements, let us first of all analyze what the term settlement means. Settlement, also known as indefinite leave to remain, and in certain circumstances, not with global talent visas, but in some other certain circumstances, for example, when someone applies as a adult dependent relative, they can get indefinite leave to enter. Indefinite leave to enter means that someone gets the indefinite leave from outside the UK. Indefinite leave to remain is when you get your indefinite leave when you are in the UK. Well, settlement is a legal term which defines a process of becoming an ordinary resident in the UK without any immigration restrictions imposed on your stay. What restrictions can the Home Office impose on your stay? These restrictions, by the way, are also known as conditions. Well, in almost all cases, the UKVI will impose a no recourse to a public funds condition, which means that you cannot claim any benefits while some immigration restrictions are imposed on your stay. Also, very often, if your country is on the special list, you will be requested to register with the police and to keep them informed of your change of address at any time. And of course, all visas have a limited time, so they are time limited. And when they're not, they're called indefinite leave to remain. Global talent visa holders are the darlings of the Home Office, and unlike the majority of work-related visa holders who can generally apply for indefinite leave to remain only after holding their work-related visas for 5 years, exceptional talent visa holders can settle in the UK only after 3 years. Global talent migrants in the exceptional promise category can apply for indefinite leave to remain only after 5 years, as everyone else. Also, there are relatively fewer rules which you need to meet if you are applying for indefinite leave to remain in the global talent immigration category. Okay, let us have a look at them. These three key elements of a successful global talent indefinite leave to remain application are the suitability requirements, the eligibility requirements, and the procedure. Let us start with the suitability requirements. The decision makers will always start considering indefinite leave to remain applications with ensuring that you meet the suitability requirements. In other words, that you are not caught by any general grounds for refusal, which you may find at Part 9 of the immigration rules. There are two types of general grounds for refusal: mandatory and discretionary. When you're caught by mandatory grounds for refusal, the decision maker has no choice and needs to refuse your application. If you are caught by any discretionary grounds for refusal, this means that, as the term suggests, the Secretary of State can either allow or refuse your application. In other words, they have discretion. Let us have a look at mandatory grounds for refusal. The indefinite leave to remain applications will always be refused if a person has been convicted of an offense for which they have been sentenced to imprisonment for at least 4 years. If their conviction was for less than 4 years, but for more than 12 months, they will need to wait for at least 15 years,
before applying. And if there was an offense for which they have been sentenced for imprisonment for less than 12 months, then the waiting period is reduced to 7 years. And they will need to wait for at least 2 years before applying for indefinite leave to remain if they received a non-custodial sentence or other out-of-court disposal that is recorded as a criminal offense. Okay, what about discretionary grounds for refusal? The Home Office may refuse your indefinite leave to remain application, and the term is may, remember, because they have a discretion, if you made some false representations or did not disclose some material facts when applying for a previous visa. And also if you did not comply with some conditions which were attached to your current or your previous visa. It may happen when, for example, you claimed benefits despite having a no recourse to public funds condition attached to your visa. There is a provision which allows the Home Office to refuse your indefinite leave to remain application if he becomes undesirable because of his conduct, character, or associations, or the fact that he represents a threat to national security. It can also happen when the person offending has caused serious harm, or the person is a persistent offender who shows a particular disregard to the law. It is possible when a person has been charged with several non-custodial sentences within a short period of time. And also the Secretary of State can also refuse your application on discretionary grounds if they ask you to provide some information or attend an interview and you fail to do so. And also the UKVI may also refuse the application if you have any unpaid debts to NHS which exceeds £500. All your NHS costs are likely to be met through the Immigration Health Surcharge scheme, which you paid when making your first Global Talent visa application. And the final reason for refusal on discretionary suitability grounds is when a person did not pay some litigation costs awarded to the Home Office, which is highly unlikely to be applicable in your case. Okay, guys, as you can see, there are many general grounds for refusal. However, it is highly unlikely that any of them will apply to you. However, if you believe that you can be caught by any general grounds for refusal, you should never ignore them and take effective steps to correct the situation. If one or more mandatory grounds for refusal applies to you, it is possible that the only option you have is to apply for further leave to remain until you become eligible to apply for indefinite leave to remain. And luckily, due to very unique nature of global talent visas, you can apply for visa extensions for an unlimited number of times. With regards to discretionary reasons for refusal, you should not ignore them either, hoping that the Home Office will exercise the decision in your favor. You need to do something about it because it is highly likely that they will be quite reluctant to exercise the discretion in your favor. For example, if you have some unpaid litigation costs, you need to repay them before applying. If you cannot do much about them, at least you need to write a very detailed letter in support of your indefinite leave to remain application, explaining why the decision maker should exercise the discretion in your favor. However, generally, if any of the general grounds for refusals apply to you, I strongly suggest that you approach a competent immigration advisor for advice before proceeding with your indefinite leave to remain application. That was our suitability requirements. Now let us talk about the eligibility requirements. The eligibility requirements are relatively simple and straightforward ones for the global talent visa applications. So the first one is the English language requirement. This is quite interesting because global talent applicants are very few who are not actually required to meet the English language requirements when making their first or extension application. But they do need to meet these requirements when making their indefinite leave to remain application. And you can meet these requirements by either having a speaking and a listening qualification in English at B1 level or above of the Common European Framework of Reference for Languages, or having a degree that was taught or researched in English or that was actually awarded in England, or being a national of a majority English-speaking country. The good news is if you have successfully made your indefinite leave to remain application based on your B1 qualification, for example, you can meet the English language requirements for naturalization without actually needing to pass it again. Your B1 exam will need to be the home recognized English test qualification from an approved test center, and I provided you with the link in the link section so that you can check which centers are on this list. Guys, all the information about this route, so if you want to dig deeper and if you would like to know more about global talent visa applications, you can get if you go to ukvisasuccess.com/global talent, and once you request this information, you may also become a part of ukvisasuccess.com community. And I'm sending a very exclusive newsletters to this community. And on a monthly basis, I arrange various masterclasses and I create online courses, podcasts where I answer various questions submitted by my subscribers. You're very welcome to become part of it. The life in the UK test requirements, irrespective of your nationality and education, you still need to pass the life in the UK test. And to do so, first of all, you will need to buy the official handbook, which is called the Life in the UK test. And secondly, you'll need to practice. And finally, after you've practiced, you'll need to book the online test and take it. There are over 30 centers in the UK and it costs £50 to take the test. And I provided you with all the necessary links in the links section. The continuous residence requirements. To meet this requirement, you will need to spend a continuous period lawfully in the UK, counted backwards from whichever of the following dates is the most beneficial for you. So first of all, it can be the date of the application for indefinite leave to remain. Secondly, it can be the date of the decision, and thirdly, any date up to 28 days after the date of application. The length of your continuous period will depend on the category of your global talent visa. So if your endorsement was in the exceptional talent category, then the counted and lawful period, as I said before, will only be 3 years. It will be 5 years for exceptional promise category. Okay, the next one is the absences from the UK requirements. You have to be very careful with your absences from the UK. Exceeding the permitted number of absences may result in the refusal of your indefinite leave to remain application. You cannot be outside the UK for more than 180 days. That's 180 in any consecutive 12 months. It is crucial to note here that absences which count towards the 180-day limit include the following. First of all, when the decision maker may exceptionally allow absences which exceed the 180-day limit if you provide a document to confirm that your absences from the UK were due to some compelling compassionate circumstances such as life-threatening illness of you or your close family members, a natural disaster, or when you were absent from the UK to assist with a national or international humanitarian or environmental crisis overseas. Guys, I draw your attention here that according to the rules, the decision maker may exceptionally allow absences which fall into one of these categories. So this is not the entitlement, and you will need to provide a really strong evidence which will persuade the decision maker to exercise the discretion, because this is what it is. This is a discretion in your favor. With regards to national or international humanitarian or environmental crisis, this will not break the continuous period regardless of the length of the absence. One thing you need to remember is you will need to provide really strong evidence to confirm that your absence was due to such crisis. And now let us talk about periods without a valid visa. Generally, any period without a valid visa will break the continuous period. However, there may be a situation where the continuous period will be paused but not broken. It may happen when one of the following applies. First of all, where you did not have a valid visa, but then you made a successful leave to remain application and a paragraph 39E applies. Paragraph 39E is the rule which allows to disregard overstaying. Overstaying means staying without a visa for up to 14 days. For paragraph 39E to apply, you need to provide a strong document to confirm that there was a good reason beyond your control or the control of your representative for not submitting your visa application on time. Secondly, you left the UK when you had a valid visa and you applied from another country outside the UK before your old visa expired and your new visa application was subsequently granted. And the case scenario number 3 is when you left the UK with a valid visa, you applied for another visa outside the UK within 14 days of your old visa expiring, and there was a good reason why the application could not be made before your previous visa expired. The reason must have been beyond your or your representative's control. And you will need to explain this when applying for indefinite leave to remain, and you will need to provide really strong evidence to prove your point. And finally, when you left the UK without a valid visa and you applied for a new visa, however, it was refused, and then you made a further successful application within 14 days of that refusal. And if any of these case scenarios apply, then you can combine the before and the after periods. However, the gap itself will not count towards the continuous period. Okay, the next requirement is called the money you have earned requirement. You need to provide documents to show that you have earned money in the UK linked to your expert field during your most recent grant of global talent visa application. However, there is no minimum level of earnings which you need to provide the Home Office with. So you will meet the requirements provided you have some documents to confirm that you have been earning some money when working in the global talent field. What documents will the Home Office accept? Well, the immigration rules do not specify which documents you should provide. The Home Office only gives some examples of the types of the information that they may accept. However, the list is not exhaustive, so you may submit some other documents if you feel they will be appropriate. Okay, let me give you some examples. For example, if you are an employee, you can provide your pay slips showing your employer's name or a letter from your employer confirming your earnings, or your bank or building society statements clearly showing the payments made to you from the employer or a limited company of which you are a director, or a document produced by HM Revenue and Customs that show details of declarable taxable income on which tax has been paid and will be paid in a tax year. For example, a tax refund letter or a tax demand. And also a document produced by an employer as an official return to the HMRC. And this document will need to show details of earnings on which tax has been paid in the tax year. For example, this can be a P60 document. And also this can be a document produced by a person, a business or a company as an official return to HMRC showing details of earnings on which tax has been paid or will be paid in the tax year. And by the way, these documents must have been approved, registered or stamped by HMRC. And this can also be dividend vouchers showing the amount of money paid by the company to you. Okay, if you are self-employed, you can also consider providing a letter from a fully qualified chartered accountant or certified accountant who is a member of a registered body in the UK, confirming the amount you have earned. If your earnings are a share of the net profit of the company, the letter should also very clearly explain this. And also, these can be company or business financial accounts which meet statutory requirements and clearly show the net profit made. And where your evidence of earnings does not clearly show they were for work in the fields for which you were endorsed, example evidence you can provide includes a contract of service or hosting agreements between you and a UK employer or institution which indicates your fields of work. This can also be a letter from your UK employer or institution confirming that you have earned money in your field. And this is it. This is all we wanted to discuss in today's video. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law, and also I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you are subscribed to this newsletter. Have an amazing week, guys.